Imagine being sworn into the highest legal office in the land, only to be fired via email 60 minutes later. Is this a constitutional process or a crime in plain sight? Welcome to this explainer. Today, we're unraveling a massive, high-stakes investigation into the criminal limits of presidential removal power. This isn't just abstract theory, folks. It's a constitutional mystery actively testing the very foundations of the American Republic right now.
Let's set the scene. In 2026, the federal legal landscape was completely rocked by the shocking dismissals of U.S. Attorneys Roger Rogoff and Donald Kinsella. Both of these men were unanimously appointed by federal judges to fill long-standing vacancies. Now picture this. Rogoff actually arrives at the courthouse, gets sworn in, and while he's literally sitting in the lobby waiting for his very first meeting, his phone buzzes. It's an email. He's fired. And Kinsella? He experienced a nearly identical, incredibly abrupt termination just hours after his own private ceremony. The administration's legal justification for these abrupt firings introduces our first major twist. Deputy Attorney General Todd Blanche posted on social media, quote, "Judges don't pick U.S. attorneys, POTUS does. See Article 2 of our Constitution." Boom. This instantly creates this massive tension between constitutional executive privileges and statutory law. I mean, is the president simply exercising their rightful authority, or is this an illegal circumvention of the entire justice system?
Part 1. Unitary executive versus regularity.
To piece together this massive constitutional puzzle, we have to look at two colliding legal doctrines that dictate how power is wielded and shielded in Washington. First up is the unitary executive theory. Proponents of this theory argue that a president has absolute, unfettered power to remove executive branch officers. Because this power stems directly from Article 2 of the Constitution, they argue it simply cannot be constrained by ordinary criminal statutes. So, in its most extreme iteration, this means the very act of firing a federal official simply cannot be a crime. Period. If the president wants them gone, they are gone, and the law can't interfere. Complicating the mystery even further is the presumption of regularity. This is a judicially created doctrine that forces courts to assume executive officials, including prosecutors, have properly discharged their duties in good faith. And this is where the plot thickens. It essentially shields prosecutorial charging decisions and executive actions from judicial scrutiny. It makes bad faith firings nearly impossible to prove in court, giving the executive branch a massive advantage and a wide berth when making personnel changes.
But this creates a high-stakes standoff. What happens when this absolute constitutional privilege crashes directly into federal felony statutes? Think about it. If a president fires an official specifically to stop an investigation into themselves, is that just an exercise of Article 2 removal power, or is it straight-up obstruction of justice? It is a legal gray area where constitutional law and criminal law are in a dangerous head-on collision.
Which brings us to a critical question. If a president uses an official power to commit a felony, should they be immune from prosecution? Comment your thoughts below. I really want to know where you stand on this.
Part 2. The Saturday Night Massacre.
Now, this dangerous legal threshold has actually been tested before. Back in 1963, courts upheld the judicial appointment of U.S. attorneys in cases like United States versus Solomon. But then, in 1973, we saw Richard Nixon's notorious Saturday Night Massacre. Nixon notoriously directed the firing of Archibald Cox, the independent special prosecutor investigating the Watergate scandal, in a desperate bid to save himself. Bridging the gap from Nixon all the way to the modern controversies of 2026, we see a historical continuum of the executive branch testing its boundaries and utilizing that removal power during times of intense political friction.
Part 3. Selective prosecution and self-coups. The plot thickens even further when the removal power is allegedly weaponized to target perceived political enemies. We are moving from just firing people to actually putting them in the crosshairs of the justice system. We've seen a rapid succession of indictments against high-profile figures who have historically clashed with the administration. Former FBI Director James Comey indicted for lying to Congress, New York State Attorney General Letitia James indicted for bank fraud, and former National Security Advisor John Bolton indicted for mishandling classified information. And because of that presumption of regularity we talked about earlier, it is incredibly difficult for defendants to prove they are being unfairly targeted for political reasons, leaving the justice system highly vulnerable to manipulation.
The official rhetoric often directly mirrors these actions, looking at official White House messaging that visually embraces the aggressive posture surrounding these legal battles, like leaning into the phrase, "I was the hunted, now I'm the hunter." It really blurs the lines between objective justice and political retaliation. It adds a deeply unsettling layer to the mystery of how executive power is being deployed.
But the stakes peak at a terrifying hypothetical explored in our sources, the concept of a self-coup. Imagine a scenario where a president fires uncooperative military or Department of Justice officials for the express purpose of illegally overturning a valid election. By weaponizing the removal power to purge anyone who won't comply with illegal orders, the path to authoritarianism opens up rapidly, creating a systemic collapse of our checks and balances.
Firing officials specifically to advance those goals would normally trigger massive federal felonies. We're talking seditious conspiracy, obstruction of justice, coercion of political activity, and interfering with federal elections. Yet, if you subscribe strictly to the unitary executive theory, you might argue the president remains untouchable, totally insulated by their Article 2 privileges. It begs the question of whether the executive branch has a built-in loophole for criminality, allowing a leader to dismantle the republic from the inside out.
Part 4. The void removal theory.
Just when it seems the executive branch might be completely immune, legal scholars introduce our final paradigm-shifting twist, the void removal theory. This theory suggests the shocking idea that an illegally motivated firing might simply lack any legal effect. If a president exercises their removal power to violate a generally applicable criminal statute, they forfeit that constitutional power entirely. The firing becomes legally void. This implies a terrifying, or perhaps brilliant, idea that a fired official could legally just ignore the president's order if that order is part of a criminal conspiracy. So here is how this countermeasure works in practice. Step 1, an illegal order is given by the executive. Step 2, the official refuses to comply. Step 3, the president retaliates by firing them. Step 4, because that firing is just a link in the chain of a criminal conspiracy, the void removal theory argues the president forfeits their Article 2 privileges. The firing is void, and the official technically retains their authority. It's an absolutely incredible legal countermeasure to absolute power.
As this explainer reveals, the battle over the executive branch is not just history. It's an active, unresolved mystery playing out in real time. How we balance the president's constitutional authority to govern with the criminal laws designed to prevent corruption will ultimately define the future of American constitutional law.
Is the law a shield for the president or a sword for the people? Hit the subscribe button for the latest sport updates.